Okay, guys, we are tight on time today, and so I want to go ahead and get started. I know some of you are still joining, but we have a lot of great material to get through, and I want to make sure that I don't keep anyone over our time allotted for today. This is one of my favorite types of topics to talk on because I think for HR professionals, you're always we one of the questions we always get asked is kind of what are the issues that you're seeing, and so today I'm going to be going over just some of the top 10 pitfalls or, reoccurring issues that I encounter in advising clients on a day-to-day basis. My name is Emily Mack. I'm a partner at Burr and Foreman in the Nashville office. And I, of course, focus my practice on employment law, advising, counseling employers, and defending employment claims. And so I think that the topics we're going to hit today are going to be timely and relevant, for all of you. And if you have questions, please feel free to just kind of, unmute and interrupt, or you can also drop a message into the chat and I will try to get to you. If for some reason I don't get to your question, please feel free to shoot me an email. My information is going to be on the last slide of this. You can also, Google me and find my email. And I'm happy to answer that question for you because this is really supposed to be for your benefit. So if there's anything that I haven't touched on or that you want me to touch on, please feel free to ask. All right. So we're going to dive right in here with the first pitfall. And the first pitfall that I see is inadequate investigations. Now, these are not, let me just preface this. This is also not listed in any particular order. And so there will be some common themes that you're going to see that kind of tie in overall with these things. But inadequate investigations is one. And there's several different roots of this problem. Sometimes we have an anonymous or a confidential complaint and no investigation is conducted. I've seen that happen before because we don't really know what to do, where to start. And depending on the context of the complaint, that may or may not be appropriate. But at the very least, if we don't have enough documentation or information to go on, given what is reported by an anonymous complainant, then there should be some type of documentation that indicates that that was the determination that was made and why that determination was made. More often than not, though, there's enough to go on. But because we receive this in an anonymous fashion, the company or whoever receives the complaint, may perceive that there's no obligation there, that we don't need to do an investigation, and that's simply not the case. Going through the motions is another thing that we see a lot of the time. I completely understand advising employers how much time investigations can take. On top of all of your other job duties, now we have a complaint. And not only do you have to review the complaint, interview the complainant, interview a respondent, interview any witnesses, collect any supporting documentation, it is a huge time commitment to do an investigation the right way. And so often what we will see are steps that are missed there. Most frequently, what I see is, frankly, we do all of the right things when we're investigating, but then we fail to properly document what we did and what we found. And 2 or 3 years down the road, when you've won the lottery and moved on from your present company and aren't there anymore, it doesn't help or do any good if we don't know exactly what the steps of that investigation were, exactly what the conclusion was. And so going through the motions, performing an incomplete investigation is something that I see come up a lot. A conflict of interest. Is the person who is investigating the complaint biased in some way? There's a lot of investigations that may get done before the issue ever, rises to the level of HR. It's the interpersonal conflict, not harassment, not discrimination or retaliation, but just kind of, inner workplace conflict may be investigated on some level, by a supervisor. Is that supervisor also friends with the person that is a respondent in that investigation? And if so, then the credibility of the investigation just isn't credible, and that can be problematic. Casual approach. just, kind of not so, we know as HR professionals that there can be certain employees who, may be in your office more than others, right? And sometimes that can be frustrating because they're constantly complaining about different things, and you've looked into every single one of these, and by the 10th one you just start to say this person is crying wolf, and I don't view this in the same way as I would other ones. But it's very important, to, no matter what the context, no matter who the complainant is, we want to maintain the same integrity and steps, given the nature of the investigation. That does not mean that you will approach every investigation in the same way. Some investigations are inherently more serious than others because they could give rise to liability against the company, given the nature of the complaint, versus my boss is mean to me, and is he mean to everyone? Well, yes, he's mean to everyone. That's more of a personality issue, and maybe doesn't warrant the same type of approach as harassment, discrimination, whistleblowing, some type of fraud, or those types of issues. But what we want to have is your same kind of format and approach when you assess the nature of the investigation that you are going to be engaging in order to, again, lend credibility to it. And then if you're late to the party, I mean, if we're investigating after the fact, after we've received the EEOC charge, it's not to say that we shouldn't do it in some instances if that was our first notice of whatever the person is complaining about, which can be the case. But, that does, it can be suspect if, if we, it has been previously reported, we don't do anything, and only once a lawyer gets involved or once we receive a charge, then the company takes it seriously. So something to keep in mind. So how do investigations lead to a pitfall? Some of these are required by law. Obviously, we know from a discrimination and a harassment standpoint, there's an affirmative obligation of the company to take prompt and effective remedial action to address complaints of discrimination or harassment. And so in those instances, we have a legal obligation to do it. And we know from the standpoint of how juries look at things that if it's not in writing, if they can't point to the report or look at the report, they're going to assume that it didn't happen, even if you've gotten up there and testified about who you spoke to and what you did. If there is not a report that that we can produce and provide at the end of the day that kind of indicates what was done, memories fade over time, and juries simply don't trust that it was done the way that we say that it was done. And so contemporaneous documentation is perhaps the most important part of the investigation, and it should be very, very factual in nature. So these types of having this documentation is absolutely critical when it comes to defending any type of discrimination or retaliation claim. One of these types of lawsuits can be very expensive to defend. And one of the things that I often recommend when we have a good investigation is to go ahead and produce it. It just shows that the company followed its procedures, it followed its processes, and it can gain us some leverage in negotiating any resolution of that type of a cause of action or claim. So having this type of documentation is certainly critical. And you will hear me say documentation is going to be a theme that comes up in many of the pitfalls that we're going to touch on today. So how to avoid this pitfall? You want to properly document all of the investigations, take appropriate actions based on the findings, and promptly investigate all complaints. I'm going to put a plug in here that if you're attending or considering attending the upcoming Tennessee SHRM conference, which is in Nashville this September, we are going to be doing, myself and a colleague are going to be doing a in-depth how to conduct investigation seminar during the Sunday session. So sign up for that. We're going to be going through real life kind of practical scenario and giving much more detail on how to avoid the pitfall of any type of inadequate investigation. And then what we're not going to do is just ignore it and hope it goes away. So that would definitely be what we want to avoid. All right, so pitfall number 2, failing to conduct training, especially for your supervisors. Guys, you probably know this in HR, but your supervisors are really your first line of defense. You are the subject matter experts. You understand the laws, you know the exposure areas, and you know what we need to do to be compliant. But if something doesn't ever come to your attention, we can't help the company defend against these claims, maintain compliance, and do what needs to be done. So if you know what the FMLA is and you know what the company's obligations are when it comes to providing notice of rights and responsibilities, or you're very familiar with ADA and accommodating employees, the liability and the claims here come from supervisors. They come from the supervisor who is trying to be accommodating, doesn't want to get HR involved. Someone needs to go out for surgery. We think it's just going to be 3 days. They don't mention it to HR. You don't get the paperwork. Next thing you know, Susie's been gone for a month and no one has done what they needed to do, right? This should sound familiar. So it's critically important to make sure that your supervisors have training, particularly as we are seeing now, younger individuals being promoted into maybe their first management roles and newer managers. We cannot assume that all of our managers are aware of this. And so I see oftentimes companies will train managers on sexual harassment. That's great. We have to do that because obviously there's vicarious liability when it comes to supervisors and knowledge of sexual harassment claims. But what I'm seeing more and more is the ADA issues, the FMLA issues, the retaliation, and so making sure your supervisors are aware of and understand why it is so important to treat everyone equally and to apply policies in a consistent and fair manner when it comes to dealing with employees, to avoid any perception of retaliation or unfair treatment. And, that is where I think this is probably one of the most critical areas where we're not seeing the investment from many companies in those types of training. The same things that I get on the soapbox about when it comes to documentation and performance reviews and write-ups, it all starts with your supervisors. You're there as a support for them, but really they are the ones that need to be doing it because they are the ones that are encountering these issues on a daily basis. Of course, we are also living in a digital world. Everyone has a phone on them. Your supervisors and you should assume that at all times in any kind of uncomfortable situation or discussion with an employee, you're being recorded. And so they should be acting accordingly and conducting themselves accordingly. Tennessee is a one-party consent state. That means that either party to a conversation has the ability to record the meeting. I understand many employers have policies that prohibit that. The extent to which we can enforce those is going to depend on the situation and the context. But if it's a disciplinary meeting, just assume you're being recorded. And there's not a whole lot you can do to stop it or prevent it in those situations. So I think I've hit on a lot of the points on this slide, so I'm probably going to kind of breeze through it here. But your supervisors are the ones that have the most legally significant tasks. Asking the wrong questions in interviews, going through the hiring process and having someone ask for an accommodation and them not understanding that the company has an obligation to accommodate individuals with disabilities with respect to reasonable requests for accommodation. Leave, that I will hammer that all day because it is such a big issue that we're seeing, particularly with the growth and expansion of mental health being more of being more prevalent in terms of employees seeking or requesting accommodations as a result of mental health, and some supervisors not understanding or realizing and recognizing the responsibilities that we have in this area. And that kind of, you either have ignorance of it or you have supervisors who try to be very accommodating and work with their employees, and it doesn't get brought to the attention of HR. We don't formally request the medical documentation to support it. And then we have, issues with inconsistent enforcement of our policies, and we get trapped into the company having given an accommodation that HR didn't necessarily review or approve, and then we have another employee who asks for it from a different supervisor, and now we have an issue. So making sure these supervisors understand this is so important. So, make sure that your training, the last point I'll make on this pitfall is that your training is not just generic. I really think that a good in-person training once a year, as opposed to a webinar or, something that is a canned, purchased program that is tailored to your company and the issues you see with your employees, is worth its weight in gold when it comes to avoiding and mitigating risk from employee relations issues. And obviously some of it's mandatory, but we shouldn't be sticking with only the mandatory points. Pitfall number 3, outdated job applications. This is an easy one to hit, these next two, so I'm going to fly through these. If you are hiring remote employees, if you are any kind of multi-state employer, then you need to pay particular attention to this, because, while Tennessee does not have any ban-the-box legislation for private employers yet, we are seeing more and more states that are adopting this legislation. As a general rule, you should assume that if we're going to hire remote employees and allow them to work in other states, then the laws of the state in which they are working may be applicable to them. And so you need to make sure that you're complying with any type of ban-the-box legislation prohibiting questions on job applications or during the hiring process about criminal history prior to a conditional offer of employment. There's also Fair Chance Act laws. Those really restrict the ability of an employer to rescind a job offer based on criminal history. So just if no one's looked at the job application in a little bit, brush it off, and make sure that we only have the questions we need to ask. We don't need to be asking, are you married? Do you have children? Where do you go to church? Any kind of outdated questions on a job application. Just if it's one of those documents that we don't look at very often, and we probably should, just to make sure we're staying compliant. So know the laws, particularly for these for multi-state employers, and don't assume that what you're using in Tennessee is going to work in other states if you're hiring other employees. This is very similar. Pitfall number 4 is pre-hire screening procedures. So the root of the problem here is either arising under the Fair Credit Reporting Act or some type of state law. Again, the Fair Chance Act laws are an example of that, where you're rescinding a job offer based on a criminal history without going through a Fair Chance Act process. That's going to require you to conduct an individual assessment, and the laws are going to vary depending on the jurisdiction that you're doing this in. But usually it involves an individual assessment requiring you to find that there is either a direct threat that is posed by the conviction that you're considering. In some states, you can only consider convictions. You can't consider arrests. And then there's similar, I guess, considerations that you need to take into consideration for pre-hired drug screens. And if you're hiring someone in New York City, for instance, you cannot do a pre-hired drug screen for for marijuana at all. It's a per se violation of the Human Rights Act up there. And so, most of the multi-state employers that we are working with, the trend has certainly been to eliminate marijuana from a pre-hire drug screen. Now, if you have safety sensitive positions or you're a DOT contractor or a federal contractor, that may not apply to you. But what we are finding is it creates more problems than the risk that it may otherwise mitigate, particularly if you're trying to keep up with multiple different state laws, because there's different types of laws for medical marijuana, for recreational, what you can consider, do you have to accommodate? And so, that's something to also make sure you're being compliant with. And then the Fair Credit Reporting Act. I'm still kind of surprised to see how many employers may not realize. They tend to assume that their consumer reporting agency is the one that is fulfilling all of the requirements when it comes to providing the pre-adverse action notice, which has to be sent anytime you are intending to rescind an offer based on a hit on a background check or any other consumer report that is compiled by a consumer reporting agency. Then you have to wait at least 5 business days or 7 calendar days before you can send the second required notice, which is a final adverse action notice. Those consumer reporting agencies, they have been targets for class action lawsuits involving these things. And so what I have seen is they have tended to push this onto you as the employer. And either way, what's important to understand is that you have independent requirements under the FCRA to be complying with this. You can't simply rely on the consumer reporting agency to be doing it for you. So make sure you are, if you are utilizing a CRA and you are utilizing functions like them sending out these notices, that you have records of those, that you've looked at them, that you feel good that they comply with the act and the requirements. So yeah, don't assume you're covered if you're using a consumer reporting agency for this. Pitfall number 5, misclassifying contractors and employees. This is something that continues to come up. I mean, it's probably once a month that I'll get a call from a client and they say, I need an independent contractor agreement. And I say, okay, well, what's the person doing? You know, what do I need to include? How are you going to pay them? And they go on to tell me that they're going to be working for them full time. It's not a defined period of time, so it's indefinite. It's a full-time role. They're doing something that sounds very integral to what the business does on a day-to-day basis, and they're going to pay them a monthly or a weekly salary. Guys, I mean, this sounds like an employee. And we just need to understand like that we as employers do not get to pick. It's not a choice as to how someone is classified. The law dictates the appropriate classification. And the best general rule of thumb that I can give you is that if this person is performing a function that is very integral to the business, you know, as in, you know, let me use this example. So a good example of someone who's a true bona fide contractor is going to be if you have, let's just say, a law firm, and the law firm has attorneys and you have staff, and the law firm, you know, wants to design a new website. What that law firm is going to do is they're going to go out, they're going to hire a website developer. The website developer is going to quote them a price that they dictate based on their overhead and their other projects and their own employees. The website developer is going to provide the tools. They have the expertise, and that website developer holds themselves out to other companies and has other projects and has other clients, right? And it's kind of a one and done thing. So that is a very easy, clean example of a true independent contractor and a bona fide independent contractor. If someone's working from you day in, day out, and is not holding themselves out to other companies, is not in some type of specialized, you know, has a specialty that is distinct from what the business does, then it is more likely than not that the default would apply, which is that they should be classified as an employee. And if you don't classify them as an employee or you don't want to, then I would strongly encourage you to seek legal counsel before making that classification. A lot of times I'll hear things like, we're hiring someone temporarily to backfill for another employee who's out on leave. And so I'm like, okay, guys, what about the only thing that makes this person different from the person who's out on leave, they're going to be doing the same thing. They're going to be paid the same way. The only thing that makes it different is that they're filling in for someone on a temporary basis. But we are an at-will employment state. There's nothing that says that, you know, that any employment has to be for any certain length of time. And that's not one of the criteria really that goes into this analysis. And so if they're doing the same functions of an employee, then the law would suggest that that person should be classified the same way. And I do think it's important in those situations where you have someone backfilling like that to go ahead and put in their offer letter, this is a temporary position. You are backfilling for someone who's out on leave and it's expected to end on this date. That way they don't think or have any presumption, that it's going to be a permanent position, but it shouldn't impact how we're classifying them as an independent contractor or an employee at all. So, make sure that I know the business folks sometimes like to lean in favor of 1099. I know a lot of contractors prefer to be classified as 1099s, but their preference is simply not relevant to this determination at all. I also see misclassification also comes up not just in the independent contractor employee context. It also comes up in the non-exempt, exempt context. And there's similarly a lot of confusion here. The default rule is non-exempt. Non-exempt means you are not exempt from minimum wage or from overtime, meaning you're entitled to time and a half if you work more than 40 hours in a single work week. In order to be classified as an exempt employee who is exempt from those requirements, you have to meet two different criteria. You have to meet a salary basis test, meaning you are paid a regularly recurring amount on a regular basis that is at least equal to the federal salary threshold. And then there's a duties test. Oftentimes, people assume that if someone's paid salary, that means they're exempt. And that's just not the case, because you're forgetting in that they're forgetting in that example about this duties test. So there are a number of different exemptions and things that will qualify, but the main ones are called the white collar exemptions. And your two main ones of those are going to be the administrative exemption and the professional exemption. And the easiest way to remember the difference between those two is that the administrative exemption is going to be you're going to be exercising independent discretion and autonomy with respect to matters of significance. So there are some positions that no matter how much they get paid, they will never meet that criteria. A receptionist is a good example of that. Just from a job duty standpoint, there's not normally going to be, if they are routing calls or directing things and doing what I would consider to be standard receptionist tasks, there's not the sufficient degree of independent discretion and autonomy with respect to matters of significance to the business in most cases. So any support staff, similarly, typically cannot be classified as exempt employees. And there are huge penalties for misclassification, both from the independent contractor and from the exempt, non-exempt. If you have someone who's classified as an independent contractor that should have been classified as a non-exempt employee, then you are potentially responsible for up to 3 years of back pay. That's going to include any overtime that they should have been paid. Take that number and double it, because they're entitled to liquidated damages in an amount that is equal to the back pay that is recoverable. Plus, then you also have to tack on the attorney's fees. And this is just from an FLSA standpoint. There can also be penalties assessed by the IRS for failing to withhold the taxes that should have been withheld. And then the Tennessee State Department of Workforce and Development will get you for the unpaid unemployment taxes that should have been withheld on behalf of those employees. And the more you have that are doing the same thing, the bigger the scope becomes, because these claims can easily be brought as what's called a collective action, which is similar to a class action for any employee who is similarly situated. So your risk is lower if you have one individual, particularly if they are not working significant amounts of overtime. But these are big penalties and big liabilities that can stack up quickly. So wage and hour is something that I would definitely recommend doing an audit, reviewing how you are paying and classifying all of your employees and contractors. If you're in doubt, classify an employee as non-exempt and classifies a worker as an employee as opposed to an independent contractor. Those are the default rules. And so if you adhere to the default rules, you should be okay, so long as we're properly then tracking their hours worked, paying overtime at the requisite rate if it's someone who's non-exempt. And then always treat your non-exempt employees as non-exempt. So again, for those individuals, we have record keeping obligations. You have to keep accurate records of all hours that they have worked, especially with phones and everyone having email on their phones these days. It can be easy for certain companies to have exposure to off the clock claims where employees are emailing at night off the clock and not being compensated for it. It's your obligation as a company to enforce your policies with respect to off the clock work. So if a manager is approving someone's timesheets every week, but notices that, Sally spends 3 hours on Saturday emailing every single week, but that's not reflected on her timesheet, the manager who's approving that, should know. I mean, and should be responsible for correcting that. Either, telling Sally you need to be paid for your hours worked, but we're not, if you aren't approved for overtime, then you can't work on Saturday. If you've hit your 40 hours, but any time that is worked needs to be paid appropriately. There was a question about what if you identify someone who is misclassified. That's going to depend on the situation. I mean, in terms of I would definitely recommend talking to legal counsel about that, because there are different ways that you may decide to approach the problem given the position, given the situation. I like, in some cases, you'll just decide to reclassify someone going forward. Now, maybe that's January 1, maybe that's, if that person leaves and you have a new person, then the new person, but, you have to fix it on a go forward basis. The strategy comes into, well, do we do anything if we feel like we owe them for anything in the past, or if we go ahead and reclassify them now, is that going to prompt them to go to a lawyer or ask questions like, why am I just now being reclassified? And so those are decisions I think that are best worked through with your counsel, and they are going to depend on the situation in terms of how you handle it. But you do need to fix it, because again, sticking the head in the sand is definitely not the solution here. But would recommend, addressing the issue and fixing it to mitigate any liability there. And then make sure that your, again, managers, supervisors are trained on these issues, that they understand that they can't ask, non-exempt employees to stay late or work off the clock without getting paid. There is individual liability for supervisors, personal liability under the FLSA, and that should get their attention. If you need anything more than that, then it's a different discussion. But once they hear that and understand that they could be personally liable, they tend to pay more attention and take these things more seriously. So understanding all of that is a good idea. All right, pitfall number 6 is failing to create job descriptions. And the reason that this really comes up, there's a few areas. I mean, number one, job descriptions on the topic we were just talking about are going to be your first thing that someone's going to look at in the event that you have a misclassification claim. So looking at, for instance, we were talking about independent discretion with respect to matters of significance. If you're relying on the administrative exemption for an exempt employee, if that's what you're relying on, then the expectation is that the job description is going to list out what those duties are. What are the areas that they're responsible for? What are the things that they can do without needing higher approval? And what are their areas of responsibility? And so, that can be a great, kind of key exhibit in defending any misclassification claim. If you're relying on the managerial exemption, which is the other common one, for exempt employees, a common white collar exemption, they have to have the ability to hire or fire, supervise at least 2 or more employees, and have the ability to hire or fire, or their recommendations with respect to hiring and firing are given significant weight. So if someone has managerial authority, their job description should reflect that. Because again, the expectation from juries, from government agencies, is that if it's not in writing, we're more skeptical of it. And so it's certainly easier for us as lawyers to defend these types of claims when we have an accurate, up-to-date job description. The other area where job descriptions are really helpful are ADA claims and defending ADA claims. I was saying earlier when discussing supervisor training, the rise in these issues that we are dealing with, and that I know I'm constantly helping my clients with, are these really thorny reasonable accommodation issues, because we don't have a lot of clear guidance from courts on what is and isn't reasonable. It's very fact specific, but I can tell you that when I have a good job description, it makes our job much, much easier when it comes to identifying what are the essential functions of this job. If it's an essential function, the EEOC and a court and a jury are going to expect that it is listed on the job description. Because if it's so important that it's essential and that we can't modify it, or it would remove an essential function of the job, then it better be in writing and it better be on the job description. So, in terms of, I like to include also things to address like mental health issues. So on job descriptions, I'll also include things like the regular attendance, the ability to work, an 8-hour day, the ability to maintain mental stamina and alertness, for up to 8 hours a day or something. I try to make sure that I'm not just thinking about physical abilities and capabilities, but dealing with things that could come up in terms of if someone's wanting to take certain medication, and those issues, making sure that we're dealing with it. And if it's a safety sensitive position, that's definitely something that should be reflected on the job description. So I think I've kind of hit why this is so important and why missing an up-to-date job description is a pitfall, but it just makes it more difficult to try to make an argument in defending an ADA claim that something is an essential job function. And then, you want to make sure that you also receive that, because when you do an FMLA certification for a serious health condition, you will, and even when I do ADA accommodations and supporting medical documentation for those, I will always provide a copy of the job description to the physician who's doing that. And the reason for that is just because I do not trust that the employee in that situation is going to accurately convey what their job responsibilities are. And so I want to know that the physician has viewed the job description and is looking at it when they are going through and identifying what the employee can and cannot do. It just helps you be on the same page with the provider so that they have an accurate understanding. And so the more information that you can provide on that, the better. Now, one note about this is that I have seen cases where employers will try to create or ask if they can create a job description after we've received a request for reasonable accommodation. I don't recommend it. In some instances, we have to do it in order to give the physician what they need to be able to go through this process. That said, I don't recommend it because it goes back to kind of bias, and having it on the front end takes all of those arguments away. If you do it on the back end, then there can of course be an argument made by the employee that that we've somehow manufactured the essential job functions to try to discriminate against them, which is not the intent. And so these are incredibly important. I know that they're the thing on your list that everyone says they're going to get to this year, and then it's difficult to find the time to actually get to them. But I would highly recommend that, in conjunction with any new hire for any new position, that's when we go ahead and we brush off and we update the job description. And I think it's a task that really starts with the supervisor, and then you can provide input and feedback on approving and reviewing it, because they're the ones that are going to know best what the duties really are, what experience is required, what are the work conditions that need to be met. And then HR can certainly sign off and provide input on that. to help. But I do think it's something that, if you kind of make it a concerted effort, it will help you with these types of claims down the road. Always make sure to, one point on this that goes back to kind of FLSA, is I like to make sure that the job description denotes the FLSA classification. Is it exempt? Is it non-exempt? And then have your employees acknowledge receipt of it, and then make sure you have your generic catch-all and other duties reasonably assigned by company. That's the one thing that I would say you want to leave yourself room to be able to revise that, to avoid getting into that fight with an employee who says, well, it wasn't listed on my job description, it's not a part of my job. Just make sure you have that bullet at the very end that says, other duties as reasonably assigned by the manager or the company. And so, yeah, those are all good tips on the job descriptions. In terms of pitfall number seven, mishandling returns from leave, this could be an entire hour. It could be 3 hours, I think, really, in terms of a topic. But I'm going to hit the high points here because it's certainly something that we continue to see. One of the, I guess the root of this issue, part of it, is failing to identify when statutes overlap, and we tend to still kind of get a little tripped up on this, although I do feel like we have, in the last few years, there's a lot more awareness and understanding about, needing to consider offering unpaid leave following under the ADA, following exhaustion of FMLA. But I still think when it comes to like workers' comp and on the job injuries, we still need to understand that all of these statutes, FMLA, ADA, workers' comp, they can all overlap, and the employee is entitled to, to get the benefits of all of these statutes. And so we can't look at any of them in a vacuum when dealing with these types of issues. And so, keeping in mind that you may have someone who gets injured on the job in a car accident and is now in the hospital, and that may necessitate, going ahead and giving them FMLA notice of rights and responsibilities, even though you're also filing your first report of injury for workers' comp purposes, running these things concurrently and consecutively as well. So in terms of mishandling leave, this is usually where the issue arises, is just, and frankly, I see it the most probably with workers' comp. Workers' comp will say, oh, well, they can't come back, you can go ahead and terminate them. Well, probably because they've reached, medical maximum improvement, and the doctor's saying they still can't return to their position without restrictions, and you don't have any light duty. Again, respectfully to the worker comp carrier, you do that, you're going to have a problem under the ADA unless we've at least evaluated those restrictions. Can we accommodate them? Should we offer additional, leave? And there's that rub where the workers comp carrier is trying to get them, back to work, so we can minimize that component of the claim, but just being mindful of the fact that they're not thinking of ADA, they're not thinking of FMLA, they're not thinking of the common law retaliation lawsuit that's going to be filed against the company for workers' comp retaliation. They're thinking of, kind of they're just staying in their lane. So I've seen several claims that have resulted because someone listened to their workers' comp broker, and then, that issue arose. So, being mindful of retaliation claims in this context, anytime we have someone who has taken leave, who has had a workers' comp injury, I highly recommend that before we're proceeding with any type of termination, you're running that through your counsel, you're vetting it, we're making sure it's consistent with how we've treated other employees who have had similar medical issues in the past, and really trying to be lenient there, because as we know, temporal proximity is the issue here, where for all of these types of causes of action involving retaliation or interference with some type of leave, the closer amount of time that we have in between a protected activity, which would be filing a workers' comp claim or taking some type of protected medical leave, and then an adverse employment action, which would be termination most frequently, the easier it is for the employee to establish that that causation element that is needed to succeed on these claims. They're still difficult to prove, and the employee still has the ultimate burden of proving them. But typically we like to recommend that we have as much time as we can in between that. Oh, there's a comment here about workers' comp settling, and I think that's a good point in terms of make sure. I have also seen that the workers' comp will settle the claim as in the injury, but they won't obtain a full release that includes the employer. And oftentimes, because of the way the worker comp approval process works, we may need a separate release. So to release any type of employment discrimination claim under ADA or for worker comp retaliation, potentially, like any common law claim, you may need that. So if your worker comp carrier is telling you they have it handled and they've settled it, sometimes that just includes the injury and wouldn't include claims against the employer that are related to that are brought under these other laws. And so again, involve your counsel, make sure that you've looked at the release, make sure that that's included, because I've had several instances where we have to negotiate that kind of on a parallel track where the employee agrees to resign, we have our release, and then the workers' comp company will have its release too. So just it's similar to that. Just make sure you think they're protecting you. They're really protecting them and their exposure on the claim, and our and that's good. But we also want to make sure that we have a full release that covers anything that they could come back and try to assert against the company. See. This I'll hit this point one more time. I think most of us know this by now, but we have to consider providing unpaid leave. And here's the other thing I'll kind of plug on this. It usually doesn't cost us very much. So if I'm in a situation where you have a person who's exhausted FMLA, they've already been out for 12 weeks, they want 3 more months. We're not sure they're really going to be able to come back in 3 months, but why not give it? At this point, we've already figured it out. They've been gone for 12 months, 12 weeks. We can figure out another couple months. And the thing I frequently hear is like, well, our people are slammed. Nothing precludes you. Again, we're going back to the temporary backfill. Nothing precludes us from hiring someone else to fill that position on a temporary basis, so long as we make it clear to the person who's coming into the position that they are filling in for someone who's on leave. And then if our employee never returns, then they don't return. But it doesn't cost us anything, and we can't really get sued when we grant approving unpaid leave. And there's a comment from Jennifer here about approving that up to a year. Completely agree with that. At that point, because the other reason for that is that the courts have said that this is reasonable, and it gets very fact specific and very gnarly when you're trying to term someone in less than that time, unless I have the exception to that would be a doctor's note who just kind of clearly lays out that it is gosh, the word I'm searching for is we don't know when it's going to end, and so at that point it turns into kind of a continuous unknown date of return. And that's when courts have said that if that you can go ahead and terminate, but I still like to approve some amount of unpaid leave, unless it's just there's no chance that the person is coming back and the doctor has said that and we feel good about the way it's been written. That's not typically what you get, though. You're going to get the medical certification that says, oh, they can come back in 30 days. And then in 30 days, you're going to get another one. Oh, they need another 30 days. Oh, they need another 30 days. And we're constantly going back and forth on extensions. The other thing I will say about leave situations, really important to document what you are approving, how long it's lasting for. If it's leave I don't just like to rely on the FMLA forms. I like to send a cover letter, and the cover letter is going to say your request for leave, whether that's FMLA, ADA, is approved. It starts on this date. Your expected return date is Y. And then here's the important part. You're going to have a paragraph that says, if you need an extension of leave or are not able to return on your expected return date, then we need to hear from you by, include 15 days before they're coming back, 10 days, so that we can get the medical documentation that we need to be able to consider an extension of your leave. And if we don't hear from you, and if you don't show back up to work, then your employment will be terminated, right? We say it a little gentler than that in my first letter, but this avoids the limbo situation of like, okay, we approved leave, then we haven't heard from them, then it's the time they're supposed to come back, and we still haven't heard from them. Well, now we never put them on notice of any of this. So you're just restarting a clock because it takes them a week to get into the doctor. Then the doctor doesn't get the paperwork back. And we know the song and dance that you end up playing. So I really think that is a critical piece of documentation. So it's so clear at the beginning of anything what you're approving, how long it's lasting for, and it just sets you up to avoid those situations. So yeah, and if I have template language for that, I think we're like recording this. I'm happy to share that, and so you can include that in your paperwork. So let me see. I know I have some questions here, and we have a few more. Let me try to get through these real quick, and then we'll look at any other questions that we have. One size is not. I think I've hit this. I've hit this hard. Maximum leave policies, 100% healed policies. We know those are no bueno. We have to consider if they can return with or without restrictions, and then not granting indefinite leave, but engaging in the interactive process. So absolutely. Insufficient documentation. I mean, this applies to everything that we've been discussing, and it's really, this should be the biggest one. Oh yeah, I gave it 2 numbers. I think that was my way of saying this is this important. So 8 and 9 is insufficient documentation here. Other people are asking for a copy of the presentation. Happy to share that with whoever would like it. But so one of the ways that this comes up is inconsistent supervisors. So I'll get a call. It's the employee's the worst employee we've ever had. They've been terrible for 5 years. We're finally ready to go ahead and let them go. And I will say, great, send me over the personnel file. And I will get it. And the same supervisor for the past 5 years has just given this person all 5s on their performance evaluations. Best employee ever, great job, great job, great job. This does not help us. This does not help us in any type of employment, termination scenario when you have bad documentation. So it's the only thing that is worse than no documentation is bad documentation. And that is an example of how that comes up. And so the other issue is we have this at-will dilemma, okay? I see this a lot with probationary period employees. All right, we're on day 89, 90-day probation period, and we say we want to cut Joe loose. He's just not working out, not a good cultural fit, something super vague and subjective, and there's no, Joe turns around, sues for discrimination, and we have nothing to support, what we meant when we said Joe was not a good fit, because, the person assumed that he was at will and we didn't need to keep any documentation. Okay, guys, these employment laws do not attach on day 90 of employment. They start on day 1 and they also apply before. And so we still need to do documentation, maybe less documentation for a newer employee, and maybe we're more apt to go ahead and term someone if they are exhibiting serious issues, right at the outset of employment. but we still need, just because they're at will doesn't mean that employment laws do not exist or are in a vacuum. And so making sure we have the documentation. And this goes back to the supervisor training I was discussing, because that's really where this would start, is with the supervisor. I'll see supervisors that have, say, I have so much documentation on this employee, and I ask for it, and it's all their personal notes. Like, they've been keeping like a manifesto of all of their issues with this employee. That is not what I'm talking about either. It's got to be documentation that goes to the employee and is accurate. So I'm gonna get, I know I'm running out of time, this is my soapbox, but require the performance evaluations. They at least force the employer or the supervisor once a year to sit down, but make sure you prompt those supervisors how important it is to be candid, and on them, so that they have the expectations, they know the consequences. And if we don't have great, well-defined procedures for write-ups and stuff, this, if nothing else, it forces you to sit down once a year and have some type of documentation on how this employee is doing, which is a great process to have. And then you, of course, want to have all the supporting documentation, name, date, signature. Person doesn't sign, it's okay. We can just write that they refuse to sign. It's not the end of the world. I'm not, for a lot of, it depends on the company and the nature of the business, but I'm a big fan of just, we don't need a write-up or a counseling statement for everything, but you can turn around and send an email that confirms the discussion you just had with the employee in your last one-on-one. As discussed, here are the issues I'm seeing. Here's what needs to be corrected. For some employees, if you're in a more kind of professional setting, that might be good. I would avoid Slack. I would avoid text message. I would avoid Teams messages. Those things are a nightmare to go back and try to recover and prove and screenshot. And so I would stick with email. You have the time, you have the date. We know it went there. We know they saw it, and avoid those other forms of communication. Handbooks, this one goes without saying. If we haven't looked at the handbook, we need to. We should be looking at it every year, or 2 years at most. And then make sure it works for you. Make sure, the one thing I'll say about this is make sure that it's not working against you too. Sometimes I'll see things like performance evaluations. We do them quarterly. Guess what we're not doing? Quarterly performance evaluations. So all you need is an employee to come in and say, I never got this, and use it against you. So it doesn't need to be in there. There's nothing, no law that says you have to have a policy about intervals for performance evaluations. So if we think that it's something that could hurt us, usually better to just take it out. I feel the same way about salary. Anything that says we're going to look at your salary once a year, we're going to adjust your salary on any type of interval. Those things usually just sometimes don't happen, and then it's better to just not have them in there. Similarly, job postings. I don't think that's a true policy. It sounds like more of an internal procedure, and it's not something that should go in the handbook. So those are just a few of my pet peeves on the handbooks and looking at them. There's a lot of stuff in the chat. I don't know if there's anything I missed that is really important here that I have time to answer. So I would say that if I didn't answer your question and you asked me one, please email it to me. My email is here, and I'll be happy to answer it. And we will share a copy, I think, of this presentation. I'm fine if everyone has it. And I will also try to attach a slide that has my recommended language on the letter as well. So I will add that to it before I provide it to MT Sherm. So thanks so much for joining me today, guys. I hope that please reach out if I missed a question. And I hope I didn't go too quickly, but I tried to make sure I covered everything. So I appreciate it. Thanks so much.
That was perfect. Thank you, Emily. Thank you, everybody, for joining. We will send out all that information, so just keep an eye on your emails. That should be coming hopefully by the end of the week. Have a good one. Bye.